Hello, this is Matt on the Moon Lambo channel, and Ripple has scored yet another legal victory against the SEC. This time, Judge Netburn ordering the SEC to hand over their internal trading policies having to do with XRP, Bitcoin, Ethereum, and crypto in general. And so SEC's having a bad day here. And this is different than the previous order that actually dates back a couple months or so ago, in which the SEC was ordered to hand over documents pertaining to Bitcoin, Ethereum, and XRP, which would get at the heart of how the SEC determined that Bitcoin and Ethereum are commodities that they really don't have any say over, versus XRP, which they are claiming is a security. So this has more so to do with the SEC employees buying and selling cryptocurrencies. What's their policies for employees? It matters for a couple of hopefully obvious reasons. There could be a conflict of interest, and also if XRP has been and always has been a security dating back for the entirety of its existence, over 8 years at this point. Did any of their employees purchase XRP? And if so, who are they? And why did they do that? Was it against the SEC's order, or did the SEC not inform their employees that they could not purchase XRP because it's an unregistered security? All of these things are obviously highly relevant. And what's super interesting, well, there's a lot of stuff that's interesting, I'll cover it in this video, but something that jumped at me right away, and this is just delicious to me, yummy, 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 because the SEC has overcharged. I've been talking about this for a long time. They've overcharged by going after Ripple executives Brad Garlinghouse, who's the CEO, and Chris Larson, a co-founder of Ripple, which is unheard of, is completely unprecedented for a case like this, because there aren't even any fraud allegations. Zero, zilch, nada, yet here we are. And I'll explain why as we go through this video, but as a result, it made it more likely that this was going to happen. And perhaps we would have gotten this court order anyway, but you will see as I go through this, definitely more likely. So this is another instance where it does look like the SEC a little overzealous in their charging, coming back to bite them on the rear side. But I do want to be clear, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say are right. I'm just an enthusiast who likes making YouTube videos as a fun hobby about Ripple and XRP and the asshats over at the SEC. And so just a very brief amount of setting the table here before I move forward. Here's an article from Forecast News from June 7th, 2021. Titled, Ripple accuses SEC of non-compliance in sharing XRP, Bitcoin, and Ether communications. And so this gets back to what I was saying just a moment ago, a couple months ago, roughly. The SEC did order that the SEC must share documents pertaining to XRP, Bitcoin, and Ether. And this was about the time we first got word that Ripple actually wanted a little bit more. And so that's why I wanted to read, there's just one or two sentences here. Ripple's defense attorneys are now asking the court to order the SEC to search for and produce documents about Bitcoin, Ether, and XRP from the SEC's FinHub electronic mailbox, the SEC's internal trading policies, that's the part that's key right there, and prescribe a deadline for the SEC to produce the documents. And by the way, I will mention also that the SEC did claim that they were going to provide a large quantity of the required documents by June 18th. We haven't heard an update on that. And but we wouldn't necessarily. If the SEC doesn't comply, then we can expect to find out via a complaint by Ripple. But if they did comply, then maybe we're not going to know anything further about this for a little bit longer here. But this is the key part here. This is when we found out that the SEC does not want to share their internal trading policies, for which really, frankly, they should be rather transparent. And so here's Crypto Law, their official Twitter account. The Crypto Law, of course, is founded by attorney John Deaton. I've got a comment from him coming up in this video, too, along with comments from attorney James Filan and attorney Jeremy Hogan, all members of the XRP community. None of them have anything to do with Ripple or the SEC specifically. Other than John Deaton, he is seeking to intervene in the SEC versus Ripple case on behalf of over 17,000 XRP holders. I'm just saying he's not a part of Ripple or the SEC. But Crypto Law wrote the following. Check this out. Breaking. Judge Netburn orders SEC to produce internal policies governing employees trading in or purchase or sale of digital assets, which the SEC has refused to do until now. see the text-only order referring to this matter. And so let me pause right there. When they say text-only, that just means there wasn't a supporting document detailing the thought process behind the order. A lot of times you do get a document. In this case, there wasn't. There was just an order, but we've got plenty of insight from attorneys here. Don't you worry. Anyway, crypto law continues. The RFP number 26 in Netburn's order refers to the letter motion from Ripple, Brad Garlinghouse, and Chris Larson of June 4th on discovery matters that can be found in our document library. Then they provide a link. Judge Netburn is, therefore, ordering the SEC to stop stonewalling and hand over policies governing SEC employees trading in or purchase or sale of digital assets and or virtual currencies, including all changes and updates to those policies to the defendants. It's a glorious thing to see, and I've argued the whole time, how could this not be relevant? Of course this is completely relevant. Conflict of interest is a real thing. But even more important than that, it's just, what if within the last year or two, key SEC employees have purchased XRP? What if that's the case? Isn't that kind of relevant? Shouldn't they have known that they were purchasing an illegal security? And if they didn't know, why weren't they informed by the SEC, which is claiming that Ripple should have known all along that what they were doing was illegal? It goes back to Ripple's fair notice defense, which is this idea that, the SEC, hey, if you're going to come after us, mind you, we've been in business, transparent, fully operating the light of day for the better part of a decade. If we weren't doing things we were supposed to do, if we were doing things we weren't supposed to do, you should have told us. And as a matter of fact, if Ripple didn't get fair notice, and that's what the court finds, then this case is over. And that's not conjecture. It's over. That's just how the law works. You cannot just all willy-nilly after the better part of a decade just decide, oh, what you've been doing is illegal and you should have known it. Like, you just absolutely, literally cannot do that. And so here's attorney James Filan, who wrote the following. The defendant's request for the SEC's internal trading policies is granted. The court finds that the information sought meets the low bar for relevance, including potentially with respect to the claims against the individual defendants. Well, how about that? Coming back to bite them, as I cited a couple minutes ago. Just makes it, because this is the thing. There's a very high bar to go after individuals, because you have to improve intent, which is different than if you're just going after Ripple. It's a much higher bar, and all sorts of stuff is now discoverable that perhaps wouldn't be, which is fantastic actually for Ripple. Not that we want the SEC to just harass Brad and Chris by going after them from a legal perspective, but it does give them more ammo. Attorney Arturo Portillo, member of the XRP community, responded to James Filan and wrote, "What are we looking for in here? A potential conflict of interest from SEC officers in case they were allowed to acquire digital assets?" To which James K. Filan, attorney, did respond with the following. The documents defendants seek in this request are relevant because they show how the SEC itself has categorized and classified XRP and other digital assets, including Bitcoin and Ether, pursuant to its own policies. The SEC's treatment of the trading in digital assets, including any distinctions it draws between XRP and other digital assets, is directly relevant to show the SEC's own perspective on digital assets, which is relevant both to the applications of the Howey test and Ripple's fair notice defense. These documents are also relevant insofar as the SEC has argued that the individual defendants recklessly disregarded that they were assisting Ripple in improper conduct, from Ripple's motion filed on June 4th, 2021. And so there you go. And which is exactly why I keep saying here. Can you imagine if they're saying, oh, Brad Garlinghouse, Chris Larson, Ripple, you're so reckless here. You disregarded the rule of law. And then if their employees are trading XRP, I swear, I hope so. I hope that's the case. Just that'll be a good time for all. And you gotta wonder what is the SEC trying to prevent Ripple from seeing here? And so James Filan then in a separate tweet wrote, "Seriously, this is great news. The SEC must be feeling so beaten down by this point." No kidding. And then you've got John Deaton here who wrote, "Why would a free and democratic government even fight the production of this information? It's called transparency. Government agencies that govern private citizens and businesses should not hesitate in providing internal trading policies regarding the markets it regulates. Ding, ding, ding. Exactly. Of course, the SEC, they're not interested in operating in good faith. This is very clear. I find their behaviors to be rather unethical, illogical, and I just don't think they give a damn. They just want to grab money and power. That is just what it looks like to me. Because what else could it be? I don't know the additional motives, but that's definitely what it looks like to me. And then you have attorney Jeremy Hogan, who wrote the following. Let's think about a best case scenario here for the SEC. It has internal trading policies, but the policies never state that it regards XRP as a security. Once that determination was made internally by the SEC, wouldn't it have made sense to inform employees? Makes sense to me. Let's think about a worst case scenario for the SEC. It has internal policies that list specific items that are being investigated and warns SEC employees that they should not trade them. XRP is not listed. Why not? If I'm the judge, I certainly want to know why. And it might not be this document, but if I was Ripple, I certainly would have asked for the names of any of the 4,300 SEC employees who have traded XRP since 2014 to present. I am very curious to know the answer to that. Very curious indeed. You're not the only one, Mr. Hogan, that's curious. Moon Lambo is curious as well. And what he linked to here was this from Harvard Law School Forum of Corporate Governance. And let me just read the first sentence and you'll get the gist of this because it's titled Stock Trades of SEC Employees. In March 2009, H. David Kotz, the Inspector General of the SEC, released a report outlining the questionable trading activity of two lawyers employed by the SEC's enforcement decision. And so I don't want to go through this whole thing. It's outside the scope of this video, but suffice it to say, this type of stuff clearly matters. And to pretend today that it doesn't, that the actual trading activities of your employees, especially when you're governing over markets that directly have to do with the trading of the specific assets that you're handling here. Well, of course that's relevant. Absolutely, of course it's relevant, and to pretend that it's not, it's just you're insulting everyone's intelligence. Of course, that's not something they care about, obviously, but this is what they're doing, and so this is what we're working with here. A bunch of baby back biatchows. That's exactly what they are. But I'll tell you what, you can call Ripple the bus driver because they're taking the SEC to school, and you can call me a shovel because I dig it. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Nambo.